Now, today we have with ourselves Advocate Abhisthela. He has successfully fought in the recent Aditi case and has won the case and brought the two shift examination to a single shift examination. Let us welcome him and understand how he won the case and how we in future should, as a doctor community, should we fight for our rights. So, very warm welcome to you, Advocate Avishthela. So, can you walk us through how this
Thank you
case
so much.
originated?
This case originated initially from 2024, before the examination, as last year 2024 examination was scheduled on 11th of August. Several students reached out to me and we filed a petition, but unfortunately the petition could not get its fate and it was dismissed because it was taken up on 9th and examination was on 11th. So thereby it was dismissed and not entertained. Then again this year several students reached out to me, but unfortunately, they decided to not go with me, and some other lawyer was hired. But there were several students from the group who were in regular touch, and they wanted to discuss the case with me and get the insights of what are the chances of the case. So there was one petitioner, one person named Dr. Aditi, who was part of that group. She reached out to me, and she is in Delhi only. So we met at my office. We discussed the case, merits of the case thoroughly, and after discussing the case, she was very much intrigued by the knowledge which I have over the issue, subject matter, and other things. So then we decided to file the case. So we filed the case on 29th of April, and the matter was approved on 1st of May, and the first date of hearing was on 5th of May. Thereby, the matter went on. There were several dates given. Firstly, it was given 20th May, but the hearing could not go. Then on 22nd May, hearing could not go. Then finally, the matter was heard on 30th of May. And after going through the detailed arguments and the rejoinder which we have filed and the reply which we had, the petition and the rejoinder and the reply, the judges were convinced that two shift examination will violate Article 14. So thereby, they allowed for the single shift examination. So that's in a very summarized way was the journey through.
So, what were the primary concern that led Aditi and other petitioner to challenge the two shift format of NEET PG 2025?
Primary concerns were let's like Dr. Aditi, who appeared last year as well, because of the two shift and the normalization, she was personally affected. In the first two attempts, where she was not very well prepared, she got a rank of around 23,000, 25,000. But because of the introduction of two shift and normalization, her rank inflated for around 15,000. And there were the other petitions as well. They were personally affected by this. So the challenges which which was the primary challenge behind before us was how to convince the court in a very simple language the effect of normalization and the two shift. So thereby we did our research, drafted the petition, focusing on how two shift is violating the fundamental rights of the doctors. And once the point of fundamental violation of fundamental right was established, our petition was ready to go through and we went forward with it. And we were lucky that the judges accepted the fact that two shift violate Article 14. Then second challenge which we faced was gathering the petitioners, because everybody is afraid being the part of the petitions. People were willing. There were other petitions filed, so students were donating amount. More than thousands of students donated a lot of amount, because of which the other petitions were filed. But still, despite donating, they were not ready to be the face of the petition. But Dr. Aditi took the stand. Initially, she was all alone. Then she discussed with few of her friends. Then one of her friend, Dr. Atashi, she got convinced, and she also agreed that this is violating their fundamental rights. Then she got further five, six more people, and that's how we gathered seven petitioners.
So, what were the key legal arguments presented against the two shift examination? How did you demonstrate that it compromised fairness and transparency?
The key arguments was the first and the foremost argument was that let's assume there is a single seat for which two students are fighting, and both the students are being given different question papers. So when both the students are given different question papers for the same sheet, for the same seat and the same examination, then that is not providing the equal playing field for to both the students. Second main argument was that it will be merely a contemplation and assumption, saying that the student who's appearing in shift 1 or who's the topper of shift 2 will score the same marks if he appears in shift 1, and it will be merely contemplation and assumption that a student who has scored, who's the topper of shift 1, will score the same marks if he appeared in shift 2, and on the basis of which normalization was being issued. So the two shift examination, that thereby we argued that giving separate question papers is violating Article 14. Further, in an examination as such, where the issue of moderation, scaling, then rationalization, all these things are of vital importance to establish the balance so that there is no unfair practice and the students get equal playing field in this examination. That was argued. Then there was one argument by then let's come to that later. There were several other arguments which was raised by the NB. We'll come to that later. But these were the key arguments against the two shift, and that it does not take the linear qualitative skill of the student into merits, into accountability. Then by two shift examination will turn a merit based examination into a luck based examination. So all these points were argued and the court accepted it.
Okay, let's move on to the some courtroom dynamics. So, during hearings, what were some of the most compelling moments or exchanges that you believe influenced the Supreme Court's decision?
See, initially, when our petition was notice was issued on 5th of May, the matter was supposed to be listed on 30th, after a week, you can say. But the date of hearing which was given to us was 20th. Then on 20th, CGI announced that firstly, there was an issue which we got to know that matter will be taken up before the registrar. So we mentioned the matter on 19 before the CGI. Then it was allowed, the mentioning was allowed, and the matter was supposed to be taken on 20th before the CGI. But then in the evening, it was announced that 20th is fixed for the Waqf hearing. Then again, we were concerned what will happen. Then on the next day, the other lawyers, they mentioned the matter. Then it was allowed for 22nd. But then again, Waqf matter took up and the hearing could not be commenced. Then we were finally given a date of 30th of May. And when date of 30th of May was given and 2nd of June was decided to for the declaration of test centers, we were really disheartened. And I was very personally very disheartened and I was just hoping to get some chance to present my case. But when 30th May came and the matter was taken up, firstly, from the rejoinder, the judges were very clear that two shift is directly violating fundamental Article 14. Then there was a argument by the NBE or by the respondents that only seven petitioners have come forward, and there are 2.4 lakhs to 42 2 lakh 42,000 who are total who have filled the application form. So out of 2 lakh 42, only seven have come forward. So only seven have problem with the two shift examination and blah blah shit. This was the argument by the NBE. So against this, and this was the key moment for me personally as a lawyer, because against this I argued that even a fundamental right of one of the petitioner, one person is being violated, the court can entertain petition under 32, Article 32 of the Constitution of India. And when I argued this, and I further argued that even if, as it is very obvious that if fundamental right of one doctor is being violated, then this particular examination, this particular process is bound to violate the fundamental right of all the candidates, all the students who will be appearing in the examination. And when I argued this, when I spoke this point, presented this point before the judges, the judge who was sitting in the center, and that is Vikram Nath sir, he was looking at me and he smiled. And then the judge who was sitting on the right, Dr. Sanjay Kumar sir, Justice Sanjay Kumar sir, he immediately pointed out to the NB that even if one petitioner is suffering, one person is suffering, that is enough. And I guess that was the point where I believe that we have got over single shift.
So let's focus on the Supreme Court's observation. The Supreme Court's
Yeah,
emphasized the arbitrariness of the two-shift format and potential for unfairness due to varying difficulty levels. How did the court
yeah.
articulate these concerns in its judgment?
The judgment is yet to come because the petition is still not has not been decided yet. There were several issues which we have raised, like two shift normalization. Then there is lack of transparency. So all these aspects. So the court has only decided the two shift issue yet till now, and further issues, normalization, lack of transparency, and other aspects where we have asked for answer key and other right of evaluation that will be heard on 14th of July. So after they filed and we filed the reply, we filed a rejoinder in which we elaborated each and every point on how this two shift examination is uh, arbitrary, how there is no opaqueness in the system, in the process of the examination, how two shift examination is violating the fundamental rights, how two shift examination is not giving equal playing field to the students, how two shift examination is uh, taking away the merit of the examination. Because in an examination as such as NEET PG, where a single examination will decide whether the student will become a radiologist or a surgeon. And one mark, even a one mark, creates a huge difference here. And by giving two shift examination, giving different question papers, and where the difficulty level of the question papers is not defined clearly, as they said that it will be almost equal difficulty level. But when NBA in itself is saying almost equal, that is thereby it is very evident to say that the difficulty level of the question papers, both the question papers, will not be same. So let's say I sit in an examination in first shift and I get question paper A, which is a bit easy, and my friend you appear in shift B and you get a question paper which is bit difficult. I score 715 marks, you score 702 marks, 700 or 700 marks. But I scored whatever marks I scored. That is my skill based on the question paper which I got. What is my you can say uh, mm, mistake here, that I happen to appear in first exam, in first shift, and what is the mistake of the other student who appeared to happen to appear in second shift? So that is how the level of fairness was not being maintained. And when we examine this in the light of principle doctrine of proportionality, so the balance between the administrative action and the and its impact on the fundamental rights, so that has to be managed. There was no balance which is being created by tuition. So court kept all these under observation, uh, observed that it is an arbitrary process and it may give right to unscrupulous malpractices, and thereby court was convinced that single shift is the only option to avoid all these anomalies.
So NBMS is often seen that they pose NBMS is often seen that they give the argument of logistic challenges. So how did the court address these concerns and what solutions were proposed to facilitate a single shift examination?
Yeah. So when the NBE posted their logistical challenges that they won't be able to, because as of now, I guess in 179 cities, they have around 450 or 500 test centers, 400 or 500 test centers they have. But their outsourcing partner, they have outsourced the centers, uh, computerized based centers to TIS ION, TCS ION, sorry. And TCS Ion on their website has claimed that they have more than 6,000 centers, 6,800 centers, and in more than 600 cities, 670 cities. So we argued before the court that when they have already outsourced the centers, the management of the centers to TIS ION, TCS ION, and they have already claimed that they have more than 6,800 centers. So it will not be a problem for TIS ION, TCS ION to arrange another 500 centers for the NBMS and for the conduction of NEET PG. So the court was convinced that they can easily arrange those centers. There might be some delay, which NB themselves agreed that there might be some delay. They won't be able to conduct the examination on 15th of June. and for that they filed a IA also seeking extension. But yes, court accepted this fact that they can easily manage it. They might need some time, but they can do it. And agreeing to it, the court allowed for two shift, asking them to arrange for more centers.
Okay, so do you foresee this judgment setting a precedent for other competitive examination in India? How might this influence examination policies moving forward?
It will definitely create a huge impact. And rather, I believe that all the examinations in which the number of students are less than 4.5 lakh, say all these examinations can be very easily managed and commenced in a single shift. So this exam, this particular judgment, this particular order, and this particular judgment, this case, will lay down the path for all such examinations to fight for fairness and justice, and fight for commencement of single shift examination, so that their fundamental right is not being violated, and they get a level playing field. On also, they should believe that whatever result has come forward, and whatever admission or seat they have got, it is purely based on their merit. There is no other luck factor or anything as such. It is entirely their merit, because of which they have got what they deserve. So this will definitely lay down the path for that.
So, in a earlier question, you said that NBMS is often NBMS should also be knowing that the number of TISO ions centers. So, why they are inclined towards conducting it in two shift? What is their interest?
Uh, is saying anything on that, that why they are so adamant on they were adamant on conducting the examination in two shift. There are a lot of speculations, conspiracy theories, and a lot of things which are behind it. But I am not going into the conspiracy theories. But what NBMS was trying to do here was, let's say, I am selling you something, or I am doing something for you, and I have made a product for you, but you're not liking the product. So it is very obvious that you will raise your objections, and being a service provider, I will have to make the necessary changes here, and I will also have to maintain the level of transparency and fairness in the process. What NBMS was trying to do was, they were forcing everything on the students. They were forcing two shift examination. They are forcing that they will not declare the answer key. They are forcing that the right of evaluation of the question papers or the answer keys, that has been closed. They are forcing that they will not disclose the raw marks of the students. So there is a level of opaqueness which has been created by NB, and NB is forcing everything on the students. Nahi, we are saying it, so you will have to accept. And when in such a situation where I am selling something and I'm forcing you to buy something without you willing to buy it, the only purpose which I have here is, because if you will ask me to change it or make some changes into it, I will incur some more cost, or I may suffer loss as well, because I might have taken money from the other people to complete this project. But as you did not agree, and I will have to redo it, I will incur some more cost. So that might be the possibility, that they might be afraid of incurring more costs or something like that. But that's just a speculation. The reasons, true reasons, are not known to us.
Okay, so on a personal note, what does this victory mean to you as a legal professional? And was there any particular challenges you faced while representing the petitioners in this case?
As a legal professional, this victory means a huge victory for me, because I'm a first generation lawyer. I'm from Allahabad. I came to Delhi 2015 and started off my litigation in 20 since 2017. I'm working as an independent practitioner, and it is cases as such which gives opportunity to young lawyers like me to establish their name and get the fame we deserve. Establish the merit, establish our name in the profession, show the world that yes, we have the merit, and if given an opportunity, we can do wonders. So this victory personally is a huge victory for me, and I'm sure that this will add great future possibilities and opportunities for me. And sorry, I forgot the second part of your question. Please, if you can help me with that.
So, were there any particular challenges you faced while representing the petitioners in this case?
Yeah, the challenge is, as I mentioned earlier, the biggest challenge for us was gather the number of petitioners. Because where lakhs of students are appearing, and we even started a Google after we filed the petition. Only 7 petitions were there. So just to check on how many people are seriously affected by it, we started a Google campaign, Google signature campaign. And in that Google signature campaign, more than 12,000 students gave their signatures. So just imagine, 12,000 students are willing to give their signature for the Google form, but none of them are willing to come forward and be the petitioner. So that was one of the biggest challenge which we fought. And the second biggest challenge was our petition. We were given dates after dates, and our petition was not being heard. So that was disheartening us at some to some extent. But after the petition was taken up and we were heard, we were given the opportunity, and matter went on for 40 minutes. So that concern was over.
So, see, still there are a lot of opaqueness on part of NBMS also, and then when we go towards counseling, there is a lot of opaqueness and a lot of luck factor there. So, what message would you like to convey to NEET PG aspirants and other students who might feel disadvantaged by systemic issues? How can they seek redressal through legal avenues?
See, all the students, my message to all the students who have been victimized by the process, by the system, whenever you see that there is any violation of any of your rights, or you feel that something is being done for you which is not acceptable to you, raise your voice. And the first thing which a person can do is writing a mail to the concerned authorities, or writing representations to the concerned authorities. Writing representations, if you need help of a lawyer, there are several lawyers out there who are willing to help all the students. I personally did this matter pro bono. I did not charge a single penny from this case from the petitioners. So similarly, if any of the students who are facing this issue and they feel that they are being victimized and targeted by the system, and there are some issues, some malpractices which is going on in the system, and any of the students wants to fight against it, I am always up for the fight. And I assure you that I'll do it for the, if possible, I'll do it for the minimum charge, or I'll do it pro bono. But the first and foremost, it is the student who have to take a stand for themselves.
So, could you share any behind the scene insights or anecdotes from the case preparation or courtroom proceeding that stood out to you?
Uh, the case room proceedings, that was the fun part here, because the strategy and be on all fronts they tried to delay the matter. Anyhow, they just wanted to delay the matter. Like our matter first was notice was issued on 5th of May. Technically, we would have given next date of 13th or 14th or 15th, but we were given 20th of May as the second date. Then few days after, on 14th or 15th, I asked my AOR. Sorry, my AOR is Advocate Sukriti Bhatnagar. She's my college junior as well, and she's a brilliant lawyer. So she is my AOR in this May case. So I asked Sukriti to file an urgent mention letter so that our matter can be heard before 20th. But our urgent mention letter was not accepted because we were informed that NBE will be up, the matter is listed before the registrar on 20th, and NBE will appear on 20th, and they will ask for time to file the reply. And if they would have appeared on 20th and asked 4 weeks, which is a technical time which is given to them to file the reply. So we were informed that NBE will appear on 20th, and they will ask for 4 weeks time to file the reply, and the registrar will grant it to them. So against this, I mentioned the matter on 19th. We were allowed to, the hearing will be done on 20th. Then again, 20th could not be hearing could not be done because of the work. Then another date was given on 22nd. Again, work hearing was there, so we could matter could not be heard. And after 20th, we were given date on the first. We were given a week commencing from 26th, but after 26th, the matter was not heard. Finally, 30th May was given. And then on 30th May, matter was taken up. And meanwhile, because I had filed an ex parte stay application, so NBV was forced to file their reply, because now on 20th, matter was being listed before Mr. Gavai, Chief Justice of India, B.R. Gavai sir. And if NBE would have asked for time to file reply on 20th, my interim stay application, ex parte stay application would automatically would have got into picture, and the court would have granted a stay. So this compelled NBE to file the reply before 20th. Then, as the hearing was scheduled on 30th of May, so I got sufficient time to file the rejoinder. So I filed the rejoinder as well. And there, that's how we strategically target, not targeted, but strategically challenge each and every step taken by the NBE in order to delay the matter or in order to win over this case. But our strategy, we were lucky that our strategy worked out, and judges were very thorough with the rejoinder which we filed. And after going through the rejoinder, the case was allowed in our favor.
So well, let us move towards the closing thoughts. So finally, what are your thoughts on the broader implication of this judgment for educational equity and the role of the judiciary in upholding students' rights?
Upholding students' rights wherever any fundamental right is being violated. But there is a speculation among lawyers as well, and there are several other speculations among students as well, that if there is any issue against an examination which is of national importance, firstly they should move against it in high court. But by this case, it was established that if fundamental right of one of the candidate is being violated, Article 32 can be invoked, and the court will hear the petition, hear the plea of the petitioners or the person or the petitioner. So sorry, the point I was saying here is, sorry, can you repeat the question? I just missed it out.
So, what are your thoughts on the broader implication of the judgment for educational equity and role of the judiciary in
So
upholding students' right?
yeah, so broader implications is that whenever, as we have seen already, whenever there is any particular issue against the national examination, the students are afraid of going forward with it, saying, thinking that how can one person change these, challenge this case or win over this case against the such a huge tyrant. So this judgment will surely ensure the path of educational fairness and equity and transparency in examinations of such vital importance, where examinations as such, which are career shaping or life shaping examinations. So these examinations, this judgment will surely create a broader equity or equitable ground of fairness and justice for the students to fight for their rights.
Okay, so anything you want to say or convey which I might not have covered in this whole interview?
No, no, you have definitely covered all the points, and it was a very well articulated. The questions were really well articulated, and thank you for having me on board. One message which I would like to give to the masses and all the students is, don't be afraid. Don't be afraid thinking of the cost you will incur in fighting the case, or what that the particular system can target you, or you will be targeted personally or something like that. No, until and unless there are, see, as we all know that there are a lot of things which is going on in the nation which is absolutely against the right of the students. But if we students will stop fighting against these tyrants or these practices, then we will not be given any opportunity of being heard. And don't worry about the cause. There are people, there are lawyers like me, there are many lawyers like me, and there are several others who will fight your case for free. In this case, trust me, I have personally paid 11,000 rupees to the AOR as the clerical charges, for the filing and the documentation and other things. So when we are fighting for causes, the cause doesn't matter. And we as lawyers can only fight for such causes when somebody like Dr. Aditi will be bold and courageous enough to take a stand for all alone without even thinking of a iota of second thought that what will happen to her or she will be targeted or something like that. So until and unless you guys are bold enough, we won't be able to help you. So let us help you and take a stand for yourself. That is my message to the students who are hearing me here.
So it was really great having you on my channel, and my best of luck
Thank you
for
so much.
all your future endeavors. And Thanks, and thanks a lot.
Thank you so much, Rohit. Thank you so much.
Uh,